The Declaration of Independence lists some of our inalienable rights. It also says that to secure these rights, governments are instituted among men. If governments are created to secure our rights, does that mean they have the legitimate power to regulate them? Now, in many situations, governments at all levels claim that power. So what happens when we, the people, allow governments to control our rights? Or, more importantly, what can we do to regain control of our rights? We'll discuss that next on the Constitution Study.
One thing you have to know wherever you make your stand came from a long through line of everyday Americans.
Hello there, everyday Americans. Welcome to the Constitution Study. I'm glad you could join me. We're doing a lot of work here, and I'm hoping you're checking out not only the website, constitutionstudy.com, but you're checking out the radio program on americaoutloud.com. I'll talk a bit more about that at the end of this video. But I want you to know that there are places you can go to both see and learn about the Constitution, find others that are interested, and become part of a larger community. Again, I'll talk more in detail at the end of the video, but right now let's talk about this regulation of our rights. During the ratification debates, one of the reasons the Federalists were opposed to the Bill of Rights was the fear that if we put a list of rights in the Constitution, someone would think they had the right to regulate them. History has shown there was merit to the Federalist concern. Enter Title 40 of the United States Code, Section 5104. Capitol grounds and building security. Firearms, dangerous weapons, explosives, and incendiary devices. Any individual or group of individuals, except as authorized by regulations prescribed by the Capitol Police Board, may not carry on or have readily accessible to any individual on the grounds or in any of the Capitol buildings a firearm, a dangerous weapon, explosives, or an incendiary device. May not discharge a firearm or explosives, use a dangerous weapon, or ignite an incendiary device on the grounds or in any of the Capitol buildings, or may not transport on the grounds or in any Capitol buildings, explosives, or any incendiary device. This law places the sole discretion over who is allowed to bear arms on the Capitol grounds in the hands of the Capitol Police Board. Now, this is in direct violation of the Second Amendment to the Constitution of the United States. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. However, there's an interesting twist to this law. Members of Congress are not subject to it. See, Article 1, Section 6, Clause 1 of the Constitution reads, "The senators and representatives shall, in all cases except treason, felony, breach of the peace, be privileged from arrest during their attendance at the session of their respective houses, and in going to and returning from the same. While it may be against the law, and constitutional and void as that law may be, members of Congress are exempt from arrest since this is not a felony." No one seemed to care very much, at least not until Lauren Boebert won her seat in Congress. Representative Boebert stated that she would carry her firearm on Capitol grounds. Well, that is a violation of 40 U.S.C. 5104E. As a member of the House of Representatives, she is privileged from arrest while in attendance at the Capitol, which quickly led to the introduction of H.R. 545, the No Congressional Loophole Act. Exception. Notwithstanding subparagraph A, the Capitol Police Board may not authorize or permit a member of Congress or an employee of such member of Congress to carry on or have readily accessible to such member or employee a firearm, except a member or employee may store a firearm in a car owned by such member or employee that is parked in the garage in the Capitol complex if the member or employee is in compliance with the firearms laws of the District of Columbia for the lawful possession of such firearm, and such firearm is locked with a gun lock while on the Capitol complex. There are a couple of things I noticed in this legislation. First, all it really does is tell the Capitol Police Board that they may not authorize a member of Congress or an employee to carry a firearm at the Capitol. To my knowledge, the Capitol Police have not authorized Representative Boebert to carry a firearm, so nothing has changed there. Which leads to the second point. See, when it comes to congressmen, it means absolutely nothing, since it would be a violation of the Constitution for the Capitol Police to arrest a senator or representative while attending or traveling to or from a session of their respective houses. What are the Capitol Police going to do? And just imagine Representative Boebert or another member of Congress filing a complaint with the Capitol Police, or with the FBI for that matter, of a violation of Title 18 United States Code Section 242 for denying them a right protected under the Constitution of the United States. Unfortunately, I bet this legislation makes someone feel better. Next, let's look at the state of Illinois. See, like several other states, they require someone to possess a firearm owner identification card, or a FOID card, in order to own or possess a firearm. In other words, the states claim that their citizens must get their permission before exercising their right to keep and bear arms. This is a blatant violation of the Second Amendment, but the courts have routinely upheld this criminal idea that states can infringe on your rights if they have a good enough reason. Then, to add insult to injury, the state of Illinois makes things worse. From an audit commissioner report I read, there's also a management audit of Illinois State Police's handling of the firearm owner identification card and concealed carry license programs. Auditors say of their sample, 87% of FOID cards weren't processed in time with up to a year delay, and 60% of renewals were not processed in time with up to a 214-day delay. Of the applications auditors sampled, 43% of CCL applications weren't processed within the constraints of the law. If it wasn't bad enough that residents of Illinois need state approval to own a gun, the state can't even follow their own laws regarding the issuing of that permission. And if a right delayed is a right denied, then this is even more evidence of the state of Illinois denying the rights of their citizens. Not to be outdone, Governor Gavin Newsom of California, in what appears to be a fit of pique, decides to abuse the rights of his citizens because he doesn't like how the Supreme Court is handling a case from another state. I am outraged by yesterday's U.S. Supreme Court decision allowing Texas's ban on most abortion services to remain in place, and largely endorsing Texas's scheme to insulate its law from the fundamental protections of Roe v. Wade. But if states can now shield their laws from review by the federal courts that compare assault weapons to Swiss Army knives, then California will use that authority to protect people's lives where Texas used it to put women in harm's way. Look at the reasoning Governor Newsom is using. He doesn't like the fact that the Supreme Court of the United States has not issued an injunction against a Texas law currently being reviewed by the federal judiciary. Forget the fact that the court noted that the request for an injunction was not legitimate, since it attempted to enjoin someone who cannot use the Texas law, ignoring the fact that the potential harm of issuing an injunction would be quite permanent. The baby is dead. While the harm of waiting until the courts have issued their opinions is generally not. I mean, after all, unless the pregnancy is approaching term, there will still be time to kill the baby should the Texas law be found unconstitutional. The Supreme Court decision not to issue an injunction that would not stop the law does not prevent another court from deciding that a case brought against someone performing or receiving an abortion can be found unconstitutional as well. Nope, Governor Newsom isn't happy, and someone is going to pay. So to whom does Governor Newsom focus his ire? Well, on gun owners, of course. So the most unique aspect of the Texas pro-life law is that it authorizes private parties to sue rather than making abortions a criminal offense. Now, I have my issues with this part of the Texas law, mostly on its vagary in who is allowed to sue. So I guess Governor Newsom is planning to allow private parties to sue California citizens for owning a legal firearm? That doesn't really surprise me, as it complies with so many of the irrational attempts of the anti-gun movement to get around the law and the Second Amendment to get their way. I also find the language Governor Newsom used to be quite interesting. Yes, AR-15s have been described as the Swiss Army knives of firearms, not because of their innocuous nature, but because of their versatility and ability to be customized. Just look at the comparison he's making, though. Governor Newsom claims that restricting quote-unquote assault weapons that saves people's lives just after the Kyle Rittenhouse case, where he used one to save his own life. He also claims that the Texas pro-life abortion law puts women in harm's way while ignoring the fact that many little girls and boys are killed every day in elective abortions. Governor Newsom's announcement is a double whammy when it comes to infringing on people's rights. Yes, he wants to deny people in California the right to keep and bear arms, at least ones he thinks are scary. He also wants to deny people their right to not be deprived of their life without due process. Not bad for a single announcement. Now, while all three of the examples I've used in this video relate to firearms, there's much more at stake. We've all seen governments claim the authority to control what you say, how you run your business, even what you put in your body. All of these are infringements on the people's rights protected by the Constitution of the United States. Perhaps it's time we the people reminded our employees in government of the consequences of failing to protect our rights. As the Declaration of Independence points out, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. Sure, all of today's issues dealt with firearms, but that was a theme. There's certainly more available. Everything from mass and vaccine mandates to SOGI laws involve telling you how to live your life, what to put in your body, and infringing on your rights, claiming the authority to tell you how to live your life. Now, those in government get away with it because we don't fire them for it. That makes it our fault. Now, the good news is you can learn to live as a free citizen. Yeah, there's some risks involved, but the rewards are pretty good. Now, please check out the website constitutionstudy.com. Find these articles, videos, podcasts, all the information you can use. Sign up for the newsletter. Hey, ask a question. I love answering questions. In fact, twice a month I put on a live Q&A. It's available on YouTube, Rumble, and on the website. But I also want you to check out constitutionscholars.com. That's where we meet together and we can discuss, we can study together, we can form study groups and learn about our rights and how to live free. But I also want you to check out America Out Loud. Now, I've been on there for quite a few months now. I have a daily program Monday through Friday, 4 p.m. Eastern, where I talk about constitutional issues, mostly coming out of the news. These are all ways for you to get information. If knowledge is power, we need to acquire that. And the problem is a lot of this information you're shown, well, it's filtered, it's curated. I try to focus on constitutional issues, but I try to show the good, the bad, and the ugly. All these are tools so you can recognize not only what's being said about what your government is doing, but a bit of detail about what they're actually doing, going back to the documents and finding out if it's so that you can be better informed. Because that's really what scares politicians the most, an informed electorate. People that are willing to hold them accountable for what they say and what they do. You can, again, find out more at any of these websites. By all means, if you have questions, ask them. I love answering questions. But let's follow the advice of John Jay. Read and study the Constitution. Teach the rising generation to be free. Know your rights so you recognize when they're violated and are better prepared to defend and assert them. Now, if we do that, well, the following generation can live freer than we live today. We can secure the blessings of liberty to ourselves and our posterity. And hopefully you found this useful. Hopefully you found it worth your time. So I can see you here next time on the Constitution Study.
You have to know wherever you make your stand. Came from